Good evening, everyone, and welcome to Special Education Legal Fund's December 4th webinar on divorce and special education law. My name is Christine Lai, and I am Executive Director and co-founder of Special Education Legal Fund, and we are so pleased to have you join us this evening. Before we begin, I'd like to acknowledge our corporate partners, without whom so much of the work that we do would not be possible. I'd like to acknowledge WellSpire Advisors and Eagle Hill School at the platinum level, Winston Preparatory School Group at the gold level, and at the silver level, our friends at Fusion Academy, Villa Maria School, Chapel Haven Schliefer Center, and American School for the Deaf. And at the bronze level, I'd like to thank our friends at Spire School and the Pinnacle School, part of the Greenwich Education Group School of Family of Schools. For those of you who are not familiar with us at S.E.L.F, I'd like to take a moment to introduce what we do. Special Education Legal Fund was founded in 2018 to provide resources, knowledge, and support to families in need with children in the special education system. Since that time, we have provided over $1.1 million in grants for legal and advocacy support to over 250 families across 70 school districts in Connecticut and Westchester County, New York. We do this primarily through our grants programs, the Attorney Grant Program and the Advocate Grant Program. The Attorney Grant Program provides $6,000 in legal support from a qualified special education attorney, such as the ones who have joined us this evening for our webinar. And the Advocate Grant Program provides families in need with $1,000 in advocacy support from a qualified non-attorney special education advocate on our list. Just a little note for December. In December this month, we are closing the application cycle slightly early relative to other months because of the holidays. We will be accepting applications through December 10th, conducting interviews through December 16th, and providing notification, around about December 20th. Hopefully, cross your fingers. For more information or to begin the application process, please visit our website at www.spedlegalfund.org. Next, I have a little commercial for our next webinar in January, which is on tuition reimbursement and transportation. Always a very, very sexy topic, but actually of, quite a bit of interest to families who have, who have placed their children, their students, in a out of district school setting and are interested in pursuing tuition reimbursement after the placement, or ironing out details of transportation. And for that webinar, we will have attorney Paul Barger from Barger and Gaines, Andy Feinstein from Feinstein Education Law, and Lara Damashek from the Windward School. And that is January 15th, again at 7 o'clock. You can sign up for this webinar the same way you sign up for all of our webinars on Eventbrite, and it's free, as is everything that we do online. Like to welcome Jeff Forte to our panel. I actually think that you are our chip leader in terms of webinar appearances. I was just going through counting. It's either you or Andy. This is your sixth webinar with us. You've joined us, you've done, the summer slide, you've done outplacement, you've done the new Connecticut IEP, you've done others that I can't remember, but we are really, really excited to have you join us to talk about this very important topic. Jeff is a incredible resource for students and families going through the special education process, as well as being a great friend of S.E.L.F. So welcome back to the webinar series, Jeff. Next up, I'd like to welcome Melissa Gagne to our webinar series. This is Melissa, this is your third panel with us. We're really excited to have you join us for this one. I really, I think you've done autism, you've done maybe what is an IEE, I don't remember exactly. But we're really thrilled to have you join us, not only because you have great expertise and knowledge, but because you are, of the, the warrior mom, class. And I love to see fellow warrior moms, particularly those of us who have trod the, the autism journey with our children, involved in something, as important as this. So welcome back to the series, Melissa. It's great to have you. Next up is Laura Heneghan, and this is your first webinar with us, which is really, really thrilling. And Laura comes to us from her eponymous law firm, where she represents families with our friend Stacy TA, our good friend Stacy. And she's got a particular interest in dyslexia and reading, which I think is really important to highlight, as we talk about, special education attorneys and, having different, maybe not different interests, but, some having particular specialties. Laura, you also come to us from the School of Warrior Moms, and having walked this walk with your own kids. And we're delighted to welcome you back this evening, or welcome you this evening. Sorry, first timer. And finally, last but not least, like to welcome Courtney Spencer back to the S.E.L.F webinar series. This is your third spin around the S.E.L.F webinar wheel, I think. You were actually on, we were just talking about this earlier, our last, sort of legal year in review, which we did back in 2021. It's probably time for a new one. And that was like when this series was in its infancy. And you've also, appeared on What is Outplacement, which is another really popular series, that webinar that, Jeff has been on as well. And we're thrilled to have you join us this evening. So thank you, Courtney. And my disclaimer, this webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut or New York, and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys in this panel. For webinar participants, this panel should be viewed as a public forum. Please do not ask questions via the Zoom platform, either in the Q&A or the chat, about your child or your child's legal or educational situation that includes identifiable information. Please refrain from any comments that include identifiable information, including name, grade, school, or school district. Please remember that your screen name can be visible to participants in the panel, as well as panelists and Special Education Legal Fund. This webinar is being recorded and will be distributed and shown at a later date at the discretion of S.E.L.F. So this is a really important topic, and one that I'm very pleased to finally be exploring with all of you. There's always the chatter that the divorce rate for parents with children that have special needs is higher than the national average. And I'm not going to get into to that or into the elements of family law, but I think that it's really important to talk about special education law and divorce and look at those two things through that lens, so that families who are having to go through, let's face it, both of these things are incredibly difficult and challenging to to families, to parents, to husbands and to wives. I think it is really a service for all of us to come together to talk about divorce through the lens of special education law, and what considerations families should make if this is something that's in their life path. So first of all, I'd like to, obviously thank all of you for joining us, but I want to start and, and talk about at the very beginning, which is, what's a parent under IDEA? How do we think about a parent and who has decision making for a student? Who wants to go?
I can go.
Go for it.
It's anybody that has any legal rights to the child. So whether it's a parent, a guardian, married couples have joint legal custody just by nature of being married parents. It could be adoptive mother. It could be somebody who has guardianship or conservatorship. Anybody who has a legal authority over that child is a parent for all intents and purposes under IDEA.
What happens, in a case, where the decision making isn't specified in a divorce or custody agreement? What is that, what does that look like? How is that decided then?
So if it isn't spelled out in a decree or an agreement between the parents, then it is shared between those parents equally. And that goes the same for medical decision making, educational decision making. So they're kind of, different buckets that hold the right to make those decisions. And unless it's specified in some way, the parents share those rights.
Is there any, I mean, you mentioned divorce or, custodial decree. Um, you know, when that is being, I guess, crafted in the process, how should special education be treated in that decree?
Well, I can speak from experience because I have a profoundly autistic and intellectually disabled 28-year-old, but when he was 3, I went through a divorce with his father. And the I was very wisely counseled to make sure that we had in our custodial decree, even though we were looking at joint legal custody, and joint physical custody, that there would be a determination in the decree about decision making, educational decision making, medical decision making, where one parent would have the final, and it was me, that
Mhm.
would have the final, decision making, and that the other parent had to be considered reasonably in all educational and special educational decisions. But when it came to the person making the final decision, it was identified as me in the parenting plan and in the decree. And that's so important. The other thing that was in there that I just want to highlight was if we came to a real disagreement, a fundamental disagreement, even though I had educational decision making, we had in there that that we could seek out mediation as a way to resolve our dispute. I didn't have to agree to that. But if you have shared and you don't have somebody who has been identified in those documents as having educational decision making authority, it's very helpful to have a mechanism in those documents to resolve any sort of dispute that comes up about educational decisions.
Mhm. That's really
I think
helpful.
along those lines, Christine, that it should be as specific as possible because there's a lot of different areas that are covered. And if it leaves it open to interpretation, that could be problematic. I love the idea, that Melissa had in hers that there's if you disagree, there's a way to resolve that.
Mhm.
But I think it's hard for parents having a child with a disability, going through a divorce, and anticipating all of the possible things that will happen. So
Mhm.
kind of having that catch-all at the end is good, but where you can, making it specific. And I think, one way that helps is that we are specialists in special education. Family law attorneys are not. And trying to educate them on your child's disability and how that might look differently from a typical neurotypical child going through a family situation like this. There could be additional factors that have to be taken into account and therefore put into that type of agreement.
I would agree. You want to foreshadow any financial issues that are coming as well,
Mhm.
because
Yeah, like who
I
pays for stuff, you know?
right. I'm entering into a mediation where I represent a mom, and the dad. There's somewhat cordial, but don't always agree. And some of the decisions are going to be based on finances versus best interest of the child. And because that's not spelled out like all expenses, all education-based expenses are split 50, whatever it is.
Mhm.
It is open to interpretation, and sometimes the financial piece falls on the parent who is advocating. So
Mhm.
wherever you can get something very clear how financial things that are coming up are going to be split without
Mhm.
discretion, that's going to be helpful too.
Yeah, I
And
would
what type
say,
yeah, Jeff, go ahead, sorry.
yeah, we were just interestingly, we were kind of all talking about this before we got on to live here, and it was, I think most of us on the call and our colleagues in this field, as part of like the intake, will ask a prospective client from the special ed perspective, are you divorced? And if so, who has educational decision-making authority? And we require a copy of the divorce decree to make sure you, as the prospective client, actually have the authority to retain someone to advocate for the needs of your child. And generally speaking, when you go through that process, you're going to find out how contentious the divorce is. And, just because folks get divorced doesn't mean that you have to fully spell out educational decision-making and medical decision-making authority if it's a friendly, collaborative divorce where both ex-spouses or ex-partners always have the child's interest in mind, right? So just like practically speaking, but if it's a real contentious divorce, which we all sometimes get from the special ed perspective, then yes, like this topic is for you, and you probably need to have both your family law lawyer speaking with your special education lawyer, because sometimes parents will not get that great agreement that Melissa has, that she thoroughly thought out, right? They're now thinking about it way after the fact, and then having to retain the divorce lawyer all over again, modify the divorce decree, and show examples of why the educational decision-making authority should no longer vest with both parents, because one parent is not putting the special needs educational decisions in the child's best interest. They're doing it to be vindictive against the ex-spouse, right? So that's where it gets real dicey, and that's where, if you're in that space, you're going to want to make sure that you are having your lawyers, your special ed and your family lawyer talk to each other to sort that out.
I mean, that you're describing a case, a situation where, you're talking about something that's, incredibly combative but there are also, and I think that this is true in most, in most marriages, you have a division of labor, and in most of the situations that I've seen, through S.E.L.F, there is generally one parent who is the primary advocate for the child. They're the ones that they know the teachers, they know the situation, they know all of that. And I'm not going to say that the other parent isn't involved, but they're not so much on the, in the weeds as the primary advocate. And so what happens in that case where, there's a divorce, and and the two of them are now, like no longer, well, maybe hopefully they're co-parenting together, but they're no longer married. How does that, how do you see that kind of play out for your families?
Well, I think it depends. So like if they don't get along and then they're not going to agree, and there's no educational decision making, we actually can't take the case because there's nothing we can do, as bad as that is. What I try to do, even in those cases, not those cases you just screen out, but cases where it's like a little iffy, is I try to do as many group calls as I can, answer everybody's questions, calm everybody down, help, really explain the process, and have everybody put their needs aside. But I have a ton of divorced couples that I represent who sometimes hate each other, but come together for the kid beautifully. They each have equal decision making. They each show up for the hearing or for the mediation. They put aside their differences and they really work towards the child. But the school district's going to pick the path of least resistance. So if you've got a dad who doesn't want a residential placement and a mom who does, you're not getting that placement without a court order. And like Jeff said, much easier to, in your original negotiations, to say, hey, can I have this educational decision making, versus now we hate each other and now I'm putting a spotlight on it and I'm going to go tell a judge that you're a bad parent and now I want educational decision making. That it is actually very hard to get after the fact, unless obviously there's been abuse, neglect, or something like that, absentee father.
Yeah. So
Our
that,
mother.
I
But
guess
from
that,
this perspective, it's not really any different than a married couple, right? We all have clients who don't necessarily
agree.
agree,
Mhm.
and that that makes it really difficult whether they're married or they're divorced or
Right.
in the process of it.
There's sometimes though that even when the divorce initially is, somewhat amicable, um, that, down the road there comes this big decision that has to be made, let's say about an outplacement, and a fundamental disagreement can occur at that point. So even though it didn't start out to be contentious, it
Right.
becomes contentious. We've had a couple of cases in our firm where, as divorced parents, each parent has the right to hire their own special education attorney for
Right.
their interest in the child. And we've actually had a couple of cases where there were actually two attorneys, representing the child's interest under the IDEA, which actually helped because typically we all are very collaborative, and it actually helped
Right.
the situation because we were able to really work through it,
Mhm.
as colleagues. But that can happen also.
I think too, it's important to realize it's not always these big issues. It's sometimes these unexpected issues. Like one parent wants the child to go to an agricultural school or a tech school, and the other parent doesn't, or how many AP classes the child's going to register for. Do they skip a grade? Do they get left back? Like these are all decisions that should be made for the best interest of the educationally of the child, but
Mhm.
can become very contentious if the parents are not agreeing.
Yeah, I'd say, like there's a couple big roadblocks that I think if there's anybody going through this on the audience that you need to know about. And the first one would be like, eligibility for special ed. If you're sharing educational decision-making authority, there's tricks around it. But if one parent's saying, no, I'm not going to consent to the referral and not sign off, but the other parent does, um, districts can listen to the parent that wants to refer to special ed. But then there are other districts that'll say, well, go sort this out. And then there are other districts that will say, well, we as the team want to make the referral,
Mhm.
right? So there's little tricks there. But then there's also, the selection of maybe an outside evaluator that could be tripped up. But one of the bigger things is if you actually have to sign a settlement agreement for whatever, for
Yeah.
outplacement, for reimbursement, for tutor, and one parent refuses to sign consent, and you're refuses to sign a settlement agreement, and you're under a real timeline because of funds or what have you, and they won't just sign it.
Mhm.
And to Courtney's point, it's really important to keep the actual client that ethically retained you and the spouse privy to the big moves, so they are aware of what they need to sign, because sometimes they might not even be aware of it, or how is this going to affect me,
Mhm.
right? And they're thinking about themselves sometimes more than what the child needs. So
Right.
keeping them apprised of this usually will, assuage the concern. But
Mhm.
those are the big issues when you have to sign something.
What about residency? What happens if parents live in different school districts? How does that, and then that kind of segues into the sort of whole like shared physical custody. But how does residency affect the provision of, services and, this whole process?
So it's where the child resides most of the time.
Mhm.
So I had a case where they were pinging the father's cell phone. Residency rules are insane. Like you can follow people, you can
Yeah.
record them. They are the craziest rules I've ever seen in my life.
Yeah.
And they were pinging the cell phones of my clients to try to prove the kids were spending like one extra day with dad. It was
Right.
a
So it
when it's
wasn't their responsibility, yeah,
right. When it's a
yeah.
50-50 split though, they can be considered in either town. But if they're every other weekend with dad, they in my reading of the law and the residency cases that I've done, that won't fly for true
Mhm.
residency. I don't know if you all have seen something different, but I've done enough insane here. Well, that was a special ed case where they were trying to make a residency hearing, but I've done some residency hearings and they're intense.
Yeah, and I don't think it's beyond reason that schools will send private investigators and things like that to see where the child is spending more of their time,
Oh, yeah.
especially the district that doesn't want to support whatever it is that they're
Yeah.
getting.
Yeah.
There's also the instance where the child can live with somebody other than either parent, which can happen when the parents are split up. It could be a grandparent or something like that. And, then they're, I think, even looking further into what's considered the child's permanent residence. Like when it's summertime, does the child still live there, or are they solely doing it for the school district? And if that's the case, that's a no-go.
Mhm.
Right. And just owning property too does not make you a resident. Like I have a lot of clients who are like, oh, I signed the settlement agreement. I really want to move to Massachusetts, but I'll just own my house in town X. And I'm like, no, you're going to be paying a lot of money.
Just stay right there. Yeah. Stay there. Yeah. Stay where you are.
So,
Everybody's
yeah.
good.
So where the standard is where you lay your head at night. Where's your library card? Where are you involved in sports? Where does your mail come? If you're a kid, how much mail you get, but they go through different factors to make sure that is where you reside.
Mhm.
Yeah.
And to go back to Jeff's point of, the settlement agreement, there's generally provisions that you have to prove your residence for periodically throughout the term of the settlement agreement. And that can mean utility bills and all the types of things that Courtney referenced.
It's also something though that you can consider up front in terms of a decree, because if you have shared, physical and legal custody, you can identify in the decree. So if one parent I live in Avon, another parent lives in West Hartford, but Avon will be the where the child goes to school. You can actually identify that if you have strong feelings. If somebody's going through it now and has strong feelings about, one program or school district over another, that's something that can be identified. And I actually, in the firm I used to work at, did some family law. And that's something that, that holds up in court. If it's, if you have it identified, it's held up in court before. Pre-identify the actual district if it's a shared, situation, because it can be one or the other. So, but then how do you decide which one? And so it's helpful to think about that when you're putting your decree together.
We've talked a lot or on this or a bit on this call about sort of navigating these big milestone, and a settlement, placement, identification, that kind of thing. What about the little things? And they're not little, but they're the things like where's the child getting therapy, where's, how is that, worked out, with, a shared custody situation. And, particularly, I've had quite a few cases where the child goes between, the different the different homes, and one parent adheres to one parenting philosophy and the other parent adheres to another parenting philosophy. So maybe one is more strict and adheres to a routine, which is, can be beneficial for, some of our kids that, thrive on routine and, whatever. And the other doesn't. How do parents navigate, that? Because very often that spills over into performance at school and, and behaviors and everything like that. How do you, work through that?
Well, I mean, that's a tough question. And it's kind of not a legal question, but
No, it isn't.
if I'm going to take a crack at it, I honestly think, because we've all been in those situations, right? I think that if the parents are genuinely focused on the child's needs and they're past kind of the arguments among adults, they really should be focusing on what is best therapeutically for their child. And usually if there's a divorce or a separation and there's just, night and day differences between approaches of both parents, more than not likely there is therapy involved. They should be leaning on the therapist to yoke what is most appropriate
Right.
for that child.
Yeah.
They can lean on the school
As sort of a
social
mediator.
worker.
Sort of a mediator.
Yeah.
Yeah.
Yeah. Mediator, clinical intervention, clinical adjudication, terms of art, but they should be leaning on the providers to do that, and maybe even think about, larger family therapy, whether it's individual with the child or just with the adult, because it really can impact the child, bouncing back and forth and then going to school, which is then sometimes a third approach that's sometimes not being delivered appropriately. Right. So I don't know what the rest of you think, but that's a tough question.
I had a case like this, and it was, when the child was with one parent, they would go to school and they have their homework done and everything else. And when the other parent, it was really difficult for them to get anything done and get to school. And again, it wasn't a legal issue. And kind of what you were saying, Jeff, my advice was to look at the why and try to kind of determine what was going on, because it could be a number of things. It could be that the parent's trying to be the cool, laid back parent. It could be that the child is trying to pit the parents against each other. It could be the child has, a disability, and the parent that gets the homework done is largely helping the child get that homework done.
Yeah.
And the other parent is not giving as much academic support. Now the child's feeling anxious because their homework's not done, and now they don't want to go to school. So it really could be so many things that it's got to be looked at, I think, a lens of what's going on in each home. But that's, really the job of somebody who's working with the family.
Yeah, it's beyond really what we can help with. But I have advised parents to go back to their family law attorney and give them very clear directives. Obviously, if it's anything that's, you're not taking your child to therapies or things like that, that's something a judge could certainly order. But we are limited in beyond what we can do. So what we can do is try to get the best school services we can.
Yeah. For sure.
And then they're going to have to work that out. But a lot of our job is, not therapy, but support, for our clients to be able to share what they're going through, to be able to process what they're going through. And a big, big part of what we do, even more than getting the services, is empowering the parents, reminding them that they can be confident, that they are capable, and giving them that confidence to be able to have hard conversations. Sometimes, I'll explain to my clients, okay, well, if you call up your ex and you're like, you didn't do this, you didn't do that, they're not going to hear you if you try this kind of language. I mean, it's the best I can do. Right. But that is tricky. That is a little bit beyond what we can help with.
Right. So I feel like, I guess I don't feel like
Christine, can I add one more thing to that?
For sure.
Because it just popped in my head. If it's real contentious, there's a guardian ad litem in the family court. Yeah. And you sometimes want to have the guardian ad litem reach out to one of us, because guardian ad litems don't know special ed, but they should, but they don't. Right. So if you're the parent that can hitch your wagon with your cause to what your child needs and convince the guardian ad litem, then you may further get either more support or less hours with the parent that's not doing the correct therapy, if you're hitching your wagon with the guardian ad litem.
Right. Yeah. Right. So do you all very often get called in when a parent, when a family's going through the divorce process to advise? Is that something that happens very often? Or is it more like a mop-up thing at the end when there's a disagreement?
I'm called by divorce attorneys for not related to my clients, for consultations on a special ed case. I have not personally ever been part of a client's, and I've had, unfortunately, clients who I thought were very happy get divorced mid-case, but I've never been called in. The only time, if there's a claim of like educational neglect or something, something like that. But that's very, very rare. And then I'll write a letter of all the things that my client has done and all the records and all the, backdrop.
Right.
Well, especially if you're Christine, just to go along with that, if you're representing both parents, you can talk to a divorce attorney to educate them about special education law, but you're conflicted out of talking about one parent over the other parent. You just talk in general terms
about the term
on special education law.
Right. So that being said, what are 3 things that you wish parents knew if they're going through the divorce process and they have a kid in special education? You can all
I hate
answer.
to sound like a broken record, but really the educational decision making up front, it to me is something that I would just like to flag for everyone, that it's just important to have that determined, if possible, right from the beginning.
I would say that, you know, it's a tough question to answer in the sense that there's just so many ways we can answer it, but you have to think about the level of your child's disability and the forecast of how are they going to become the most productive member of the community in which you want them to live beyond their education years.
Mhm.
And then how are you going to get there, and what costs might be associated with advocating for that? And, talk with folks like us or our colleagues or advocates and so forth, and make sure that you're forecasting these things in a divorce decree, because if you need to advocate and you're in a contentious district, which there are some, you have to think about that. And that might not be something that you're thinking about today while you're writing the divorce decree. Right. And if you are, and you have, let's say, 100% decision-making authority, but you're also getting alimony, right? Is the alimony going to cover the future potential needs of your child's educational advocacy?
I would say that even when it's difficult, it's going to be better for all parties if the parents are in agreement. And if they're not, don't disagree in front of the school district or at meetings in PPTs or in writing and copy the district, because, I think
United
Melissa
front,
said,
united front,
yeah,
united front.
exactly. I think it was mentioned earlier that school districts will at times seize on that bit of contention and make it that much worse. And I've had a case where, each parent had a lawyer and the district filed for due process against one of the parents, and the other parent was on the side of the district. And
Oh,
you can
God.
only imagine how that was decided, right?
Right.
So even if you're disagreeing, don't let that be seen. Don't fight at the PPT.
Right. Right.
And I'm going to say something a little off, which is all of that is true. Again, have your decree black and white, who has educational decision making, all those pieces. It is not an easy thing to get. Most of my clients do not have educational decision making. So what I'm going to advise is the more collaborative your divorce can be from the beginning, the more you can get along and where you can get along. That is going to be the most helpful thing. If one parent is angry and vindictive, like Jeff said, there's you could be like, they need oxygen. No, they don't. It's just not going to work. I represented a mom, and her ex called me to tell me that she had made up autism. Her son is not autistic. I mean, it was so, you know what I mean? Like,
yeah.
And you just kind of, and she asked
That's
me
the
to talk to
oxygen,
him.
no oxygen thing.
Right.
Yeah.
She asked me to talk to him, and I talked to him, and I said,
By the way, yeah.
I hear you. I have these 10 evaluations, and I was able to get him at least to listen to reason. You know what I mean? My client had asked me to do that. I don't normally do that, but the more you can, I have some clients where I'm like, wow, you guys get along so great. And the mom represent the mom, and the mom be like, I hate him, but they come to the table and they're like, it's about the kid. Make even the divorce about putting those kids front and center. I did divorce law for 8 months out of law school and ran screaming from it because, the reality is it's always sad. I got pensions, I got houses, all the things, but I couldn't put the promises back together. You know what I mean? So it's a sad time. But the more you can focus on, okay, this sad part's gonna last a little while, but we're gonna be co-parents till 18 or even older for kids with some disabilities. The more you can be on the same page, start off that way, the better. Not always possible, but if you can, it's important.
I also think it's important for your divorce attorney to really understand things like child support and how that's different for kids with disabilities. and make sure if they don't know, for example, if in some cases, child support can go until age 26, depending on now in Connecticut,
Yeah.
depending on the level of disability, but there's a very certain way that has to be structured so it's not received as income for that. And so, a divorce attorney may not understand those nuances, but they will sometimes, consult with financial advisors, financial planners, but ask those questions up front of your divorce attorney, making sure they really understand how a child support, the guidelines are the guidelines, but you really need to understand the nuances of a child with a disability when you're considering child support.
Can you expand on that, sort of this, you've opened up the sort of post 18, kind of, wormhole here, what happens after, the child turns 18? And, how do you treat that, in this kind of situation, particularly if there's a, the child's going to need care after the age of 18 or after the till 22 or 26?
Well, depending on the level of need of the child who turns 18, under the law, the age of 18 is the age of majority, where the educational decision-making authority then vests
with the child
who's now reached the age of majority, which is 18. If the family, however, feels though that the child is, not able to make their own educational decision-making authority, then that can simply be redelegated, quite simply to, back to the parents. And I suppose then it would invest back to whatever the divorce decree or the divorce agreement would say about that. And then that would continue through when they exit out, which now is June of the school year in which they turn 22.
Right.
And they can execute a power of attorney. You could do the conservatorship or guardianship. But honestly, in Connecticut, they just have to they can do a quick email and give parents educational decision making. For litigation purposes, it's always better to have a legal document like a power of attorney. I ran into that in a litigation. It was ridiculous. Because it's not required, but we had one, which was fine. But are you talking rights or are you talking child support beyond 18?
I'm all of that really, I mean, we sort of touched on the idea of child support and how that's, sort of structured. But, if we could, sort of, I know this isn't necessarily your specialty, but in terms of thinking about, because after 18 all kinds of other things pop up. You have SSI and you have DD. Well, some of these things could exist before you're 18, but how are those things affected by the divorce process?
The eligible, yeah. I mean, I think, like Melissa was saying, that the biggest thing you have to worry about is income. Otherwise, it shouldn't affect anything. If you're 18 and you qualify for SSD, you qualify for Medicaid. But if I also do a little bit of special needs trusts and wills on the side, and so you have to be very, very careful if any income is coming, any big incomes coming into the child, it will knock them out of benefits for a period of time. So being very careful. And again, Melissa knows more about this than I do. I didn't know you could get child support beyond 18, but you would want to make sure it's maybe called alimony or something so that it is clearly for not for the child.
There's certain parameters for that. So that's for kids who who have an intellectual disability or mental disability, where one parent is the primary caretaker, caregiver for that child. So there's certain parameters that you can extend it to 26.
But typically these decrees can include support for college, how college costs are going to be split. Some kids that especially we deal with have transition services, which, Jeff mentioned can go until they're 22. Medical insurance can last until a kid is 26. So there are a lot of other factors that can be spelled out that occur after a child is 18.
Yeah, the more your agreement is black and white, your divorce decree agreement is black and white and lays everything out, the less room for fighting.
Right.
Insurance is another big thing. Mom has great insurance, dad has terrible insurance, and this
Right.
child needs all kinds of therapies. Those kinds of things are important to look at over time and to come to agreement. Again, you're at the table. It's kind of like when we're at the mediation table is when like you got to put it all out there. This is your shot to get everything that this
And it
client
sounds like you have to, have, forecast a lot of potential scenarios, for outcomes that, you might not know, if you're, going through the divorce process when your child's 3. It's like, what do you know about the situation is going to be when when your child is 18, at that point. But it does sound like there's a lot of, the more you have kind of in black and white at the beginning of the process, the better off, all of this will be. What happens if there's like a major change, you remarry, or, what happens, as I continue to play what if, happens if there's an order of protection against one parent? Let's take those two things separately. So what happens in the case of remarriage?
From our perspective, nothing. Unless that person adopts the child. They have they can be part of all our conversations, but they have no decision-making authority as far as the school district is concerned. So the school district would still be obligated to communicate with both parents if they have joint custody, or the one who has, it's usually both, even if there is educational decision-making. But I've had a lot of step parents who were the ones who contact me, who are the ones that go to the meetings and all those pieces, but they don't have any legal authority to do anything, including signing documents, unless somebody gave them that authority,
right?
Either through a court order or by agreement. Sorry.
But either parent has the right to invite anybody to these meetings, which can cause issues at times if there's contentious.
Yes, sure.
But as Courtney's saying, I've seen step parents really step into a role of tremendous support for the child. So again, collaboration, and anyone who's kind of got that much contact with the child, if it's a positive relationship, can only be a good thing.
Absolutely.
You asked about orders of protection. Usually, not to genderize it, but usually it's the dad that has the protection order against the ex-mom has the protection order against the dad. And I don't mean to genderize it, but that's kind of usually the way it plays out.
Sure.
And it's really scary, and it's there for a reason. And if the divorce decree is silent as to educational decision-making authority, I've had circumstances where then the dad wants to just sabotage. Again, I'm not like genderizing it, but sabotage the PPT meeting. And at least the way I've approached it in the limited circumstances that I've had it is, we'll make sure that the school team is aware that, post-COVID, it's remote. So we're in person, they're remote. Right. So, the protection order is there. If we are physically in person, then he can't be let in the building. And then we record. And we're recording, obviously, for the benefit of the PPT, but we're also recording for the benefit of the parent. Where if there's a threat made during the PPT, then that's just another reason to then go back to say there was a violation of the protection order. But then also there's like ethical issues, like, they could try to grieve the lawyers that are trying to help the child. So it gets real dicey.
But I put a lot on the school. I've had at least one PPT where we've had the police there. The parent the previous week had come to school and assaulted a school staff, right? This is totally separate and apart from us. I represented the other parent, and there was an order of protection. There was the kid arrests, all that kind of stuff. Unfortunately, the order of protection the divorce decree still said the father had to be informed. It was very awkward. So the school's like freaking out. They are trying to keep themselves safe.
Yeah.
It's really dicey, but
But
they
they
can't
still have to inform the father, even though.
under those circumstances. Yeah.
Yeah.
So for orders of protection, anybody who's getting those, see if you can get that language in there too, that they get no contact, but they're not allowed to if there's an order, if they come into the meeting, they're going to get arrested. If there's a protection order against the kids, you make sure the school has the picture, name, all the information. They cannot come. I've had some horrific abuse situations, and person can't be there. But yeah, it is tricky because no contact, but sometimes they can still be informed. And like Jeff said, they can show up on Zoom, maybe. I think that could even be a gray area if there's an order of protection. I don't know. I know it's the physical proximity, but if they show up and they're threatening or they're
intimidating
in any way. But to me, it's safety first, because especially in-person PPTs, a lot can, you're in a closed room in a school, a lot can go wrong.
Yeah. I mean, that's a very highly fraught situation anyway, and everybody's in a room and usually everyone's upset, or at least that's been my experience, in the PBT meeting is it's a time of major upset, and all of it being heightened by an interpersonal dynamic that's not entirely productive, can be challenging. We're coming up on the hour, and I really want to emphasize again how much I appreciate the four of you joining this evening to talk about this really important topic. Just a final, what would you for parents on the call who are going through the divorce process, what's the most important thing that you would like them to take away from this call, and not educational decision making? Melissa, I'm going to take that one away from you.
Well, I would say that even if it's contentious now, I have the benefit of being on the other side of this, and my son is 28 now, and his dad and I came together, and really partnered, even though I did have the educational decision making. We really were partners in every decision all the way through his time in school. So even though right now, because that, it is such an emotional, very sad, difficult thing to go through, and emotions are so heightened at this time. But when when time passes, I would say if you can't be as collaborative as possible at the beginning, continue to try to be collaborative, because if you can get to that place where you really are partners for the benefit of your child, it can be really wonderful. And I had the benefit of having that experience for my son Ryan with his dad.
Sorry, that's my dishwasher beeping. I apologize.
That's all right.
But I'll go next.
Yes, you do.
So I would just always go back to, if you have a dyslexic child and that dyslexic child is not reading, you need to be able to read to fill out a McDonald's application, right? Like we all know that. Understand that this is going to sound bad, and I'm sorry for anybody on here who works for a school district. Your common enemy is not each other; it's the program, right? So reminding each other of that this is not about you fighting each other; it's about you fighting a machine, essentially a program that is not helping your child, and funneling it that way. You know what I mean? And I don't mean that school districts are the enemy. I'm just saying that understanding the battle in these instances is for a successful future for the child, right? And come together, and that actually saves you all kinds of money, right? If your child can become employable and independent, and remembering
and a productive member of society,
right. So
that is the
you
goal.
may have. Exactly. You may have bigger battles against, child support and all those things, but in this case, you are together, united, trying to get something for your child that will help all of you down the road.
I love that.
I would say that, you're going to be working with a divorce attorney, and to the extent that you can educate that person who doesn't have experience in special education on your child and your child's disability, because if you do go to court, they're going to be the one giving that information to the court. And it's really important that the court understand that there may be specific circumstances that are leading you to ask for certain things, but they are completely justified by the needs of your child. So I would say, interview divorce attorneys, talk to them about the fact that you have a child with some special needs and how they would go about handling that.
And one of those things, I mean, I know that, a couple of the advocates that, that we all know, have always, counsel, at the beginning of the school year, write something, maybe include a picture of your child, write, a few lines about your child, nothing like, not like a tome, but, sort of, these are my child's strengths. These are the things that that they struggle with, these are things that they like. And that helps, I mean, I think that helps everybody, but, certainly would help, because they, might not ever meet, the child face to face, probably not, so that all that kind of thing is helpful. Jeff?
Yeah, I mean, I guess the takeaway would be, you know, school districts that really have their finger on the pulse of their students are going to know that your divorce is highly contentious if it is. They're
Right.
going to find out.
Right.
And I think Laura mentioned it before, like the more laundry you publicly air through emails, through messages,
Right.
through, having to have the teacher make 2 phone calls
Right.
to the same issue
Same
to both
topic.
parents
Yeah.
because you don't want to be on. They will be aware of that. And at
Right.
the end of the day, like we here on this, and you, Christine, with yours, with what you provide grants for, we are all about the children. And this can really genuinely affect your child. It could increase their services in special ed. It could trigger special ed. It could trigger a 504. It could trigger things that you weren't aware of while the divorce was being,
Yeah.
done.
Yeah.
So just be aware of that and really try to explain to both adults that you have to be in this for the long haul for your child, which could be up to the age of 22 and beyond with services. So well, under the IDA, so 22.
And you did
But
and you actually did bring up that point about, this process and the, and the dissolution of the marriage, could be the trigger for things that didn't exist before, like anxiety and depression and, things that fall under IEDEA, which, maybe the child hadn't evidenced before, before the, the familial, breakup. And that's, and that's something that we didn't talk about, but those are also things that are, that are good to, to highlight.
yeah,
I
and
think, I'm
school
sorry.
counselors and social workers that their role is to work through these things. So you might want to lean on your school team, even if you're not triggering special ed. Let them know what your child's going through.
Going through. Courtney?
Say one last thing. Jeff
Yeah.
is so much less cynical than I am. Be very careful that everything will start getting blamed on the divorce and it will become a home issue and not a school issue. So after it's all said and done, remember to say the words, autism is not caused by divorce. Dyslexia is not caused by divorce. You know what I mean? Like, learn those mantras, because I've had to say them at PPTs to not let anybody use that to help you not get the services your child needs.
Right. Like this is the divorce, not, an underlying issue. No, that's super helpful. Thank you all so much for joining us this evening. This was incredibly, incredibly insightful. I mean, I always say that on each of these webinars, I learn something new. And, and I didn't, and that's like doubly, triply so tonight. I take my hats off to all 4 of you for sharing your accumulated wisdom and knowledge and experience with us this evening. Please join us on January 15th for tuition reimbursement and transportation. Everyone, thank you to our panelists and have a wonderful evening. Be well.
Thank you.
Thank you.
Thank you.